Last Tuesday, a green card holder landed at Miami International Airport. 7 years in the United States, no criminal record, valid permanent residence. She walked off her flight, cleared the CBP booth, collected her luggage, and was stopped by ICE agents before she reached the exit doors. Not at the border, not at the inspection booth, inside the airport, inside the United States. 3 hours later, she was in a detention facility. Her crime, an old removal order from 11 years ago that she believed was closed. It was not closed. It was sitting in a federal database. And the moment her passport was scanned at arrivals, it was visible to every enforcement agent in that building. If you are a visa holder, a green card holder, an OPT student, or an H-1B professional who travels internationally, what is happening at United States airports in 2026 will change how you think about every single flight you take. Stay right here, because the next 12 minutes could be the most important immigration information you receive this year. Welcome to Global Immigration News. Before we go into what is actually happening at airports right now, we need to establish one distinction that most travelers have never been taught, and not knowing it is costing people their freedom inside the arrivals hall of airports they thought they had already cleared. CBP and ICE are not the same agency. They do not have the same authority, and they are not operating in the same location inside the airport. Customs and Border Protection, CBP, is the officer at the inspection booth. They process your entry. They stamp your passport. Their authority is specifically tied to the border crossing moment. The moment you clear that booth and step into the airport beyond it, you are inside the United States. A different legal framework applies. A different agency can now reach you. And that agency is Immigration and Customs Enforcement, ICE, which has dramatically expanded its operational presence at major US airports in 2026 in ways that most travelers have absolutely no idea about. Here is the development that changed everything. ICE is now operating with a real-time coordination protocol at a growing number of major international airports that links directly to CBP's arrival processing system. When the CBP officer scans your passport at the inspection booth, your entire immigration history, your visa records, your prior entries, any enforcement flags attached to your name, all of it is simultaneously visible to ICE units operating inside that same airport. You clear the CBP booth, you think you are done, you walk to baggage claim, and ICE already knows you are in the building. That is the 2026 reality that nobody is explaining to travelers before they board their flights. Now, who does this coordination actually reach? Because this is not a threat that applies equally to every traveler. The risk is concentrated in specific populations, and if you are in one of them, you need to know it before your next departure, not when you are standing in an arrivals hall with your bags around you. The highest risk population is travelers with a prior order of removal, and here is what makes this so dangerous. A removal order does not expire. It does not disappear from the federal database because years have passed. It does not get cleared because you subsequently obtained a different immigration status through a different process. If a removal order was entered against you at any point in your immigration history, even decades ago, it is in the system. It is visible. And your arrival in the United States activates it. People are discovering this reality at airport arrivals in 2026 who had genuinely no idea the order still existed. Some of them had attorneys who told them it was resolved. Some had been in the United States on valid status for years since. The order was still there, and ICE was waiting. The second high-risk population is travelers with prior visa overstays, even old ones, even brief ones, even ones that happened before they obtained their current lawful status. An overstay record does not disappear when you subsequently receive a different visa or adjust your status. It is a part of your immigration history, and in 2026, with expanded vetting protocols, that history is being examined more closely at airports than it was even 18 months ago. Travelers with active removal proceedings, cases currently pending in immigration court, face perhaps the most acute immediate risk. An open immigration court case combined with an international arrival is a combination that ICE enforcement units at airports are specifically trained and specifically empowered to act on. If you have an active case in immigration court and you are planning international travel, the question of whether you can safely re-enter the United States is not one to answer with assumptions. It requires a direct conversation with your immigration attorney before you book the flight, not before you board it, not at the airport, before you book it. And then there is the population that surprises the most people: lawful permanent residents, green card holders, people who believe, reasonably, understandably, that their permanent residence card is a shield that protects them from immigration enforcement complications at the border. It is not. A green card grants you the right to reside permanently in the United States. It does not grant immunity from ICE enforcement authority. Green card holders with certain criminal convictions, even old ones, even misdemeanors in some circumstances, are facing enforcement action at airports in 2026. Green card holders who have spent extended periods outside the United States, 6 months, 9 months, a year, are facing questions about whether their permanent residence should be considered abandoned. And green card holders whose original path to the green card involved any irregularity that is now being reviewed under expanded vetting standards face scrutiny they did not anticipate when they boarded their return flight. Now let us talk about rights, because this is where the information becomes immediately actionable and where the difference between knowing and not knowing is most consequential. The moment you are inside the United States, past the CBP booth, in the terminal, in baggage claim, in the arrivals hall, you have constitutional rights that did not apply with the same force at the inspection booth 30 seconds earlier. You have the right to remain silent. When ICE agents approach you inside an airport and begin asking questions about your immigration status, your travel history, your background, you are not legally required to answer those questions. The right to remain silent is real. It is constitutional. Exercising it calmly and clearly. I am choosing to exercise my right to remain silent is not aggression. It is not obstruction. It is not making the situation worse. It is a protected legal choice that exists precisely for moments like this one. You have the right to an attorney. If ICE agents are detaining you, if you are not free to leave, you have the right to contact legal representation. Ask for it directly. I am invoking my right to speak with an attorney before answering questions. Say it clearly. Say it once, and then stop talking until that representation is available. You have the right to know why you are being detained. Am I being detained? If yes, for what reason? These are direct, appropriate questions that you are entitled to ask and that enforcement agents are required to answer. Here is the mistake that costs people the most in these encounters, and it comes from a completely human place. When you are approached by federal agents in an airport after a long flight, when you are tired, when your luggage is in your hands, when other travelers are watching, every instinct you have tells you to cooperate fully, explain everything, answer every question, provide every document, and trust that your honesty will resolve the situation quickly. That instinct is not wrong, but unlimited voluntary disclosure, volunteering information beyond what is asked, providing documents that were not specifically requested, offering explanations that open new lines of inquiry, has produced outcomes in documented cases that more precise responses would have avoided. The guidance from immigration attorneys on this is consistent and clear. Cooperate, be respectful, but be precise. Answer what is asked. Provide what is legally required. Beyond that, silence and counsel are your tools. Let us now go through the specific traveler populations most affected in 2026 and what each group needs to know. F1 students returning from international travel, particularly those on OPT, are experiencing scrutiny at airports that is more intense in 2026 than most expected. CBP officers are asking detailed questions about OPT employment. They want to know your employer, your job title, your work location, whether your work is directly related to your field of study, and they are checking what you say verbally against what your I-20 and EAD documentation shows. The moment there is an inconsistency, if you changed employers and your DSO updated your SEVIS record, but your verbal answer was slightly different from what the documentation shows, it generates a flag. Secondary inspection, phone calls to your school, delays that stretch for hours. The specific mistake that OPT students make most frequently is not carrying updated documentation that matches their current employment situation. If you changed employers during your OPT period, your updated I-20 reflecting that change, Your new employer's letter and your EAD should all be organized and physically accessible in your carry-on, not on your phone, printed, because a CBP officer who asks to see documentation of your OPT employment and receives an organized, complete, consistent package moves your case forward. One who receives hesitation, phone searching, and documents that partially contradict each other refers you to secondary. H-1B professionals returning from international travel face a 2026 airport environment that requires specific document preparation. Officers are asking detailed questions about the petitioning employer, the work location specified in the petition, the job duties, and the salary. In a year when H-1B scrutiny has intensified broadly, not just at visa issuance, but at re-entry, being able to answer these questions clearly and backing your answers with documentation is not optional preparation. Your I-797 approval notice, your most recent pay stub, your employer letter confirming your current position and location, all of it should be printed and organized in your carry-on. The traveler who reaches into a laptop bag and produces a complete organized document package gets a different reception at the inspection booth than the one who unlocks their phone, searches through email folders, and says, "I think I have the I-797 somewhere." Now, the most dangerous mistake any traveler can make in 2026, and it involves a specific situation that sounds technical but has catastrophic real-world consequences. If you have a pending I-485 adjustment of status application, if you have applied for your green card and that application is currently being processed and you travel internationally without an advance parole document, your I-485 is automatically abandoned the moment you leave the United States. Not delayed, not paused, abandoned, completely. Everything you filed, every fee you paid, every year you waited, gone. And you cannot re-enter the United States on the visa that was being replaced by the green card, because filing the I-485 typically meant you acknowledged immigrant intent, which abandons your non-immigrant status. Travelers who make this mistake discover it at the airport upon attempted return, not before departure, not during the trip, at re-entry, when it is too late. If you have a pending I-485 and you need to travel internationally, you must have an approved advance parole document in your hands before you leave. Not pending, not applied for, approved. And you must carry it with you on the trip and present it at re-entry along with your other travel documents. Green card holders returning from extended trips abroad need to carry specific documentation in 2026 that they may not have needed in previous years. If you have been outside the United States for more than 6 months, CBP officers are authorized to question whether your permanent residence should be considered abandoned, whether the United States is still your permanent home, or whether you have effectively relocated abroad. The answer to that question is not given verbally. It is demonstrated with documentation, employment records showing you maintained U.S. employment, lease or mortgage documents showing you maintained a U.S. residence, tax returns showing you filed as a U.S. resident, bank statements, evidence that your center of life remained in the United States even during your absence. Carry these documents if your trip was extended. Do not assume your green card speaks for itself. In 2026, at certain airports, it does not. Before every international trip that involves re-entry into the United States, do 4 things. Know your immigration status with complete precision, visa expiration, authorized admission period, any pending applications, any prior immigration history that could generate questions. Carry your documents physically in your carry-on, visa, I-797 if applicable, I-20 if you are a student, EAD if you depend on it, advance parole if you have a pending I-485. Write down the contact information of your immigration attorney before you leave, not saved in a phone that could be dead or taken for inspection, written on paper in your wallet. And if you have any complexity in your immigration history, any prior overstay, any prior removal proceedings, any gap in status, any extended absence, have a direct conversation with an immigration attorney before you book your departure, not your arrival. Subscribe to Global Immigration News right now. ICE airport enforcement developments, CBP policy updates, traveler rights changes. These are exactly the updates that shift without warning and that reach the people who need them last when covered only in mainstream news. We cover them when they happen. We break them down in language that is immediately usable, and follow our WhatsApp channel, link is in the description, where we send urgent travel and enforcement alerts the moment they are relevant, so you are never the last to know. Here is what must stay with you. CBP and ICE are separate agencies with separate authorities. The moment you clear the CBP booth, you are inside the United States and different rights apply. ICE airport operations in 2026 use real-time CBP arrival data to identify enforcement targets before they reach baggage claim. Prior removal orders never expire. They are visible and active regardless of how long ago they were entered. Active removal proceedings combined with international travel is a critical risk combination. Inside the airport, you have the right to remain silent, the right to counsel, and the right to know why you are detained. Exercise all three without hesitation. OPT students must carry consistent updated employment documentation. H-1B professionals must carry organized petition documentation physically accessible at the booth. Traveling with a pending I-485 without approved advance parole abandons your application permanently. Green card holders returning from extended absences must carry documentation proving U.S. ties. And preparation, precise knowledge of your status, organized physical documents, attorney contact information before departure, is the single most powerful protection available in any airport encounter. You cannot control what the system does at the airport. You can control every decision you make before you get there. Stay prepared, stay informed, and we will see you in the next video.